So in this video, I want to talk about the Supreme Court of the United States, which is commonly abbreviated as Scotus, and discuss the role that the Supreme Court plays in the creation of judicial precedent. So to start, let's review the U.S. court system. So you'll recall that we have a state court system, which begins at the state trial court, and then at the tier above the trial court, we have the state appellate court, and then at the highest tier is the state Supreme Court. And then we also have a federal side, which includes federal trial courts, which are known as U.S. district courts. And then we have the federal appellate courts, which are known as U.S. courts of appeal. And finally, the federal Supreme Court, which is known as the Supreme Court of the United States. And so when we have a case, that case can either go through the state court system or it can go through the federal court system. If it goes through the state court system, the loser at the state trial court can appeal up to the state appellate court, and the loser at the state appellate court can then appeal up to the state Supreme Court. And if it goes the federal route, it can go through a similar process where the loser at the trial court can appeal up to the appellate court, and then the loser at the appellate court can appeal up to the federal Supreme Court. And then there is one other mechanism where the loser And then there is one other phase where the loser at the state Supreme Court can appeal over to the federal Supreme Court if the case involves a federal question. Now, here's what you need to know about getting a case to the federal Supreme Court, that is the Supreme Court of the United States. So first, the Supreme Court of the United States takes cases through a mechanism called certiorari. And this just means that there is no right to appeal. In other words, if a party loses at the federal appellate court or at the state Supreme Court, they do not have an automatic right to bring their case to the United States Supreme Court. Instead, the Supreme Court will take a case through what is known as a writ of certiorari, which basically means that the Supreme Court is using its discretion to hear a case. And so, in order to convince the United States Supreme Court to hear your case, you need to file what is called a petition for a writ of certiorari, which is commonly just abbreviated as a cert petition. Now, the cert petition needs to, at a minimum, contain a federal question. But beyond just containing a federal question, it must also be a question that contains precedential value. And this means that the question must not be mere error correction. The U.S. Supreme Court will not grant a writ of certiorari if the question presented is only valuable to the parties in the case. The Supreme Court of the United States only wants to use its limited resources to resolve important legal questions. It is also worthwhile to recognize that an important legal question does not necessarily mean that the case has important stakes. There are some cases that get to the Supreme Court where the controversy is only over $1 or some other nominal damage, but the question is nevertheless important. On the other hand, there are cases that involve the death penalty that the Supreme Court doesn't even hear because it doesn't raise an important legal question, even though the stakes of the case are important to the parties. So I also want to draw an important distinction between the federal Supreme Court and the state Supreme Courts. So the federal Supreme Court has the final word on the meaning of federal law. And the state Supreme Courts have the final word on state law. And so, in this sense, the rulings of the state Supreme Court, at least as they relate to state law, are binding on the federal Supreme Court. In other words, the federal Supreme Court will not second guess a state Supreme Court's interpretation of state law. The federal Supreme Court can only review the meaning of federal law. And a corollary of this rule is that the Supreme Court will not take a case that was decided on an adequate and independent state law ground. Which means that if a state Supreme Court disposed the case based on state law, and the meaning of federal law is not material to the resolution of the case, the federal Supreme Court is not able to take that case. So having clarified that, let's talk about how the Supreme Court operates. So in order to grant a petition for cert, the Supreme Court follows what is known as the Rule of Four, which means that 4 justices need to vote in order to grant a petition for a writ of certiorari. Now, just because the Supreme Court grants the petition does not mean that it rules in favor of the petitioner. Granting the writ of certiorari just means that the Supreme Court has agreed to hear the case, but it has not yet rendered a decision on the case. And on this point, the denial of certiorari has no precedential value. So if the U.S. Supreme Court denies a petition for writ of certiorari, it does not mean that the Supreme Court endorses the lower court's decision. It simply means that the Supreme Court does not want to hear the case. However, if certiorari is granted, then the parties will file briefs, which are arguments advocating for their position, and then the Supreme Court will hear oral arguments where the justices can ask questions of the lawyers and clarify points of the argument, and after oral arguments, the court will issue a decision. So now let's talk about Supreme Court decisions. There are 2 components of a Supreme Court decision. The first is the holding, which simply says who wins. And the second component is the rationale, which explains why. And of these 2 components, it is the rationale that has the most precedential value. Because at the end of the day, after the Supreme Court issues its decision and creates a binding precedent, lower courts are required to apply that precedent in similar cases. However, it is difficult to know whether a case is similar to a Supreme Court precedent if you don't know what the Supreme Court's rationale was. And so once the Supreme Court has read the briefs of the parties and heard oral arguments, the justices of the Supreme Court will vote first on who wins and then second on why. And if a majority agree on both the holding and the rationale, you get a majority opinion. And for a long time now, a majority opinion means that you need 5 of 9 justices. And again, an agreement on both the holding and rationale. So if a majority of the Supreme Court agrees on both the holding and the rationale, one of the justices will be assigned to write the majority opinion, and that majority opinion will lay out the rationale. If one or more justices agree with the majority's holding, but not with the majority's rationale, they may write a concurring opinion. I see I misspelled rationale. So a majority opinion means that the majority of the court agrees on both a holding and a rationale. A concurring opinion is when one justice agrees with the holding but not the rationale. And finally, you can also have a dissenting opinion, which is where one or more justices disagree on the holding. Now, just because a justice disagrees with the majority's rationale does not necessarily mean that they will write a concurring opinion, and the same goes for a dissenting opinion. But oftentimes, justices who did not join the majority opinion will issue some sort of other opinion explaining why they did not join. Importantly, of these various types of opinions, only the majority opinion is binding precedent. Concurring opinions and dissenting opinions can sometimes be cited as persuasive authority, but only the majority opinion is binding precedent. Now, you might be wondering what happens if a majority cannot agree on a holding or a rationale. So if a majority cannot agree on a holding, then that simply means that the lower court's decision is affirmed. So this is an unusual circumstance because there is an odd number of justices on the court. So as long as everyone is voting, they will always come to a majority decision as to the holding. But in some rare instances, one of the justices might be recused, and so there will only be 8 justices, and they can split 4 to 4. And if that happens, it just means that the lower court's decision is affirmed, and it's like the Supreme Court never took the case. However, if the Supreme Court has a majority on the holding, but not the rationale, things get complicated. So first, instead of getting a majority opinion, you will instead get a plurality opinion. The plurality opinion is not necessarily binding like a majority opinion is. And instead, lawyers have to look at the plurality opinion and the concurring opinions and decide which of these opinions decided the case on the narrowest ground. And whichever opinion, be it a plurality or concurring, decided the case on the narrowest ground will be deemed the controlling opinion. Now, I will say that this is not a straightforward analysis, and oftentimes it is simply a point to be argued. But this is the rule that we follow when the Supreme Court fails to come to a majority consensus on the rationale. Now, there is one other type of opinion I wanted to mention, and that is called a seriatim opinion. Now, fortunately, the Supreme Court does not issue seriatim opinions anymore, but they did during the first few years of the court's existence, and there are still Old English cases that are decided in a seriatim manner, and this just means that each judge writes for himself. And when decisions are written in this seriatim format, there is no real majority opinion, and the binding precedent is really more of a vibe. I also want to mention this term that you will hear occasionally called dicta. And dicta refers to rationale not necessary to holding. And so when a justice is writing about musings in his rationale that is not necessary to decide the case, that is not necessary to the holding, then it is regarded as dicta. And dicta is considered to be not binding. Now, again, it is not a straightforward analysis to try to figure out what part of a rationale is dicta and what is holding. And I would suggest not concerning yourself when you are reading a Supreme Court opinion on trying to figure out what is dicta. However, lawyers can use the concept of dicta to construct arguments to get away from language in a Supreme Court opinion or otherwise that is not helpful to their case.